PTI was declared ineligible to obtain the election symbol which it had applied for. The order of ECP dated 22nd December 2023 was assailed before the Peshawar High Court in writ petition number 6173, which was allowed with a short order dated 10 January 2024. Detailed reasons whereof was given subsequently. Two representatives of PTI had filed another writ petition in the Lahore High Court bearing number 287 of 2024 against the ECP, which was disposed of by learned single judge with a order dated 3rd January 2024, holding that the prayer sought therein could only be granted if Section 215(5) of the Act was declared ultra vires the Constitution. But since the same was not challenged, the relief sought could not be granted. It was also mentioned that the petition was pending in the Peshawar High Court. An intra-court appeal was filed against the order of the learned single judge. However, a divisional bench of the Lahore High Court upheld the order of the learned single judge. Writ petition number 81171 and 332 remain pending in the Lahore High Court. Writ petition number 6173 filed in the Peshawar High Court did not disclose that writ petition number 81171 was pending adjudication before a 5-member bench of the Lahore High Court, even though it pertained to the very same matter, that is the holding of intra-party elections in PTI. Writ petition number 6173 filed before the Peshawar High Court was not maintainable because the same issue of intra-party elections had already been assailed by PTI before the Lahore High Court. If two and more courts have concurrent jurisdiction, while a petitioner may elect to avail of his remedy before either court, but having chosen a particular court, the same dispute cannot then be taken to the other court. ECP has been calling upon PTI to hold its intra-party elections since 24th May 2021. At that time, PTI was in the federal government and in some provinces. Therefore, it cannot be stated that ECP was victimizing PTI. Nonetheless, we wanted to satisfy ourselves that the ECP had not acted mala fide or for ulterior reason, or that PTI was discriminated against. It transpired that ECP had passed orders against 13 other registered political parties which were far more severe than the order passed against PTI. One such case of All Pakistan Muslim League came before this court on 12 January 2024, and the order of the ECP delisting the said political party was upheld. ECP wanted to ensure that PTI holds intra-party elections. The mere production of a certificate stating that such elections were held would not suffice to establish that intra-party elections had been held when a challenge was thrown to such an assertion. Nor, in our opinion, should ECP concern itself with minor irregularities in the holding of a political party's elections. However, in the instant case, not even prima facie evidence was produced to show that a semblance of elections had been held. 14 PTI members with stated credentials had complained to ECP that elections had not been held. These complaints were brushed aside in the writ petition by simply asserting that they were not members of PTI and thus not entitled to contest elections. But this bare denial was insufficient, particularly when they had credibly established their long association with PTI. And if any member of a political party is expelled, it must be done in accordance with Section 205 of the Act, but no evidence in this regard was forthcoming. Democracy founded Pakistan, a fundamental aspect of which is the ability to put oneself forward as a candidate and to be able to vote, both within a political party and in general elections. Anything less would give rise to authoritarianism, which may lead to dictatorship. The ECP is a constitutional body, and amongst its duties are those mentioned in the Constitution of the Islamic Republic of Pakistan, Article 219E of which stipulates that ECP must also undertake such functions as prescribed by law, which would include those mentioned in the Act. Section 208 of the Act mandates that political parties must hold intra-party elections periodically, and that a period not exceeding 5 years elapse within 2 elections. It further stipulates that every member of a political party could be provided with an equal opportunity of contesting election for any political party office. Unquote. Members of PTI were not provided nomination papers when they went to get them, nor were any intra-party elections held. Incidentally, the notice issued by PTI Secretariat that their elections were to be held in Peshawar, but did not mention the venue. And then the venue was shifted to Chamkani, which is a village adjacent to Peshawar. Neither before the Lahore High Court nor before the Peshawar High Court, any provision of the Act, including Section 2 and 15(5), was challenged. The observation of the learned judges that the provision of the law was absurd was uncalled for, particularly when no provision thereof was declared to be unconstitutional. Surprisingly, no declaration was sought nor given that intra-party elections were held in PTI, let alone that the same were held in accordance with the law. If it had been established that elections had been held, then ECP would have to justify if any legal benefit to such a political party was being withheld. But if intra-party elections were not held, the benefits accruing pursuant to the holding of elections could not be claimed. We also do not agree with the learned judges that the ECP did not have, quote, any jurisdiction to question or adjudicate the intra-party elections of a political party. If such an interpretation is accepted, it would render all provisions in the Act requiring the holding of intra-party elections illusory and of no consequence and be redundant. Therefore, for the aforesaid and detailed reasons to follow, this petition is converted into an appeal and allowed by setting aside the impugned order and judgment of the Peshawar High Court passed in WP number 6173P of 2023. Resultantly, the order of the ECP dated 22 December 2023 is upheld.